I want to take it from the message that came. I've also heard comments, similar comments as such, and of course it appears, unfortunately, the former CJ did not have institutional support. If you had worked in government before, you also maybe able to appreciate this point that I'm making when it comes to galvanizing institutional support. Because it appears, even on very basic applications that she makes to the High Court, she's just thrown out in a manner that you wouldn't expect a CJ, whether suspended or even a former CJ, to be treated in such a manner. So I agree with that part. But I do not think the fate of our CJ should hinge on how she relates with her colleagues. Of course, that is also not to suggest that when you are in any capacity working as a government official, you should not build a good relationship with your people. I mean, it's similar to, or is akin to that of Mr. Dampare when he left office. You recall some of the police jubilated. Others popped champagne and they celebrated. I mean, there was a mixed feeling to that. One, a cast aspersion on us as a people. Why should a section of the police jubilate because their boss has been removed? And it also raises a question of how he was also relating or working with them, ultimately. But I think the fate of any CJ should not be benchmarked on how he relates with his people or his workers. It should be benchmarked on the position of the law. I want to find out from Beatrice specifically, and this one I give the opportunity briefly. I want to know how much public funds the CJ.
Give me the opportunity.
No,
I don't take that opportunity.
I mean,
make your point. I'll respond.
For I'm not sure after my 34 minutes submission, you also have the opportunity to respond.
No,
please, but anyway, that's why I want to know how much public funds the CJ has misappropriated.
Okay.
Maybe that will give us a picture of the conversation that we are having upon which she's being slaughtered. But look, Moro, reasons have always existed for almost everything. But let the point be made, and let emphasis also be made on it, that it is not every reason that is in a reasonable form. As for reasons will always be there. There will always be justifications for actions or inactions, for omissions or actions. I did this because of that. I did not do this because of that. And especially when those reasons are justified or lays under the umbrella of the law. Remember what Baron de Montesquieu said. He was very profound and succinct when he made the point that there is no greater tyranny than the one that is hidden under the umbrella of the law or the guise of the law and in the name of justice. And I'm very much convinced that is what we are witnessing now. That there is no greater tyranny than the one that is hidden under the umbrella of the law or perpetuated under the guise of the law and in the name of justice. If you want to use the law, Moro, as a basis to justify your positions, you always do. Just like judges. Judges mostly take a position and then justify it within the remit of the law. It is the more reason why there are different opinions on the same subject matter. You go to court today, a judge will say that I see this book as blue. Another judge will say that I see this as a blue-black. And they will have a justifiable basis within the same remit of the law to justify their position. So if you keep telling me that what law did President Mahama break, what law did President Mahama break, I will tell you the provision that he breached, the constitutional provision that he breached. But before that, I want to tell you that before legality, there was conscience and morality, and there was values. That in the spirit of even building our democracy, there are oughts and what we ought not to do. That you don't just get up as one arm of the government after that myriad of criticisms prior to your ascension to the throne as the president of the country, come into power, target this woman, remove her, and you think everybody ought to clap for you. Reasons have always existed, but not always in reasonable forms. So what you've done is to perpetuate the highest form of tyranny, and now cosmetically lays it under the remit of the Constitution. Of course, if it is about everything that is being justified with the law, then I want to have a news for you. That recall that at some point slave trade was legal. Slave trade was justified by the law. But Moro, will you sit in your right conscience and say that slave trade was something that was right? No. I give you another example. PD, this Preventive Detention Act. It was legal. It was justified under the remits of our laws. And all what Nkrumah did under PDA, the Reakuto, were all done within the remit of the law. Would Beatrice sit here as a student of the law and a lawyer and justify PDA today, especially with human rights and the new position of the law and how law or the legal space has developed? Clearly no. Pioneering has been justified by the law. If you go to South Africa, interestingly, apartheid that we so much criticize and so much distaste and reject was justified by the law. So I just want to set a very fundamental principle and a basis for you, that the fact that things are done under the umbrella of the law does not necessarily make those things legally right, because even bad laws are also laws. Pioneering, all of them, human sacrifices, those chiefs in the olden days that were killing people, they were all justified by laws. When you took them to any judicial process or to face any judicial committee, they were not going to find them culpable, because the position of the law was that if a chief dies, we must cut somebody's head and bury the person. Would you also say that, because it was justified by the law on that basis, then it is legally right? Clearly no. What President Mahama has succeeded in doing is not only to bring down the needs of the judiciary to its lowest moment, but what makes me scary is how now judges may be forced to align with a political party that is in power. And that is also going to mean that in terms of consistency in their rulings, we are not going to get it. Because right now, the perception that everybody is going to get is that the new CJ obviously has to align with the NDC. And cases that may make some political interests or political connotations, obviously you may have to force to be aligned, which is, for me, very dangerous for our democracy. Not to even talk of the fact that if you look at, let's say, within the economic space, the consequential effect on our economy. Because see, I've always maintained that when we talk about the judiciary does not have guns. They do not have arms. The judiciary survives on the trust and the confidence that the people places on them. Judiciary is like money. Money is the value of money is about the trust and the value that people place on the money. It is a more reason why you pick dollar and cedi. But at the end of the day, you say that dollar is more valuable than the cedi in nominal terms because of the value that people places on the dollar. So when you have an institution that is only safeguarded by the trust and confidence that people places on them, and all you do is that you don't check the mood of the nation, you don't check the consequential effect on our economy, you don't check the consequential effect on our safety, people just lose confidence in it. What happens is that if today I am supposed to go to court and I believe that I'm not going to get justice, I'll pick a gun into my hands and then attempt to get justice by myself. Okay. Very dangerous precedent that has been set.
Kwasi, before you go ahead to talk about this issue about precedents, do I get from what you're saying, and are you suggesting that as a citizen of this country, if I am very convinced that the head of an independent institution has done something to me where that I feel very peeved about, okay, or I feel hard done by a conduct of the head of an institution, an independent institution, I do not have to go through the processes and the procedure to get justice because of the political climate that we find ourselves in? Is that what it is?
I mean, absolutely not the argument. But of course, you see, the reality is also that we cannot also be dismissive about how politicians can exploit the same processes of addressing grievances as a private citizen to perpetuate injustice, not even to the Chief Justice, but even to the entire country, of course, to get their own way. So, I mean, if we are to go by the logic that you are advancing, I'm sure we may not even be having any public officer in this country.
Right.
Because in terms of our administrative functions, some way or not, we may get lapses. If we are to go by this logic, in terms of our administration, look at one of the reasons that in her performance of administrative functions, she transferred a case or transferred a judge. And this is the basis for the removal of the Chief Justice in 21st century and 2025 in Ghana. So that's why, you see, Moro, beyond the legalities, we are people of conscience. Legalities doesn't jettison conscience.
Okay.
Legality doesn't jettison values. Legality doesn't jettison our ability to reason. And so for that matter, it will be very unacceptable for anybody to suggest that, well, I mean, this whole thing is just that clean. And I am going there. You know, she kept insisting that she want to get legal authorities and legal positions on whether or not President Mahama in this process and this procedure has committed any breach. And I'm going to go there. I'll give you one example. If you look at the processes the processes relative to the removal of the CJ, I take you to Article 14610 of our Constitution. And Beatrice, you may also just check. 14610 talks about where a petition has been referred to a committee under this article, the President may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice. As soon as you see may in the Constitution, then it becomes discretionary, right? So in this context, and under this clause, the President, as part of the holistic process of the removing the Chief Justice, of course, I mean, the process, it was a process, it was not an event. It started with the petition, determination of a prima facie case, record, then at some point suspension, then a committee was formed, blah, 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 then I'll try to move her. So it's been a process, not an event. And within this process, it's been fraught with a lot of constitutional breaches and constitutional inappropriateness. I point you to the very one, Article 146 that I read, that where a petition has been referred to a committee under this article, the President may, in terms of the suspension, may makes it discretionary. And as soon as you are exercising discretionary powers, you ought to be guided by the very principles of the Constitution. Discretionary powers are not exercised in vacuum. So if you want to enforce or implement Article 146, then you have to read it in tandem with Article 296 of our Constitution, because 296 talks about how discretionary powers are being utilized. Now I take you to 296 of our Constitution. 296C, where in this Constitution or in any other law, discretionary power is vested in any person or authority. C, where the person or authority is not a judge, emphasis here, where the person, and of course obviously referring to the person exercising that discretionary power, because already I've pointed out that the use of may in 14610 is just an exercise of discretionary power. Now, exercise of discretionary power has to conform with the very principles of 296. Let's take 296 once again. Where in this Constitution or in any other law, discretionary power is vested in any person or authority. C, where the person or authority is not a judge or other judicial officer, there shall be published by a constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this Constitution or that other law to govern the exercise of the discretionary power. Can she produce any document where this CI or SI or that regulations that the President benchmarked on reference in the exercise of this discretionary power? This is a clear breach. Yesterday, the President proceeded to remove the Chief Justice. So I've given you one instance. There is a clear breach and violation that the Constitution is essentially saying that if we are exercising a discretionary power and you are not a judge or you are not a judicial officer, you ought to be guided by the provisions of 296C. And in such circumstance, what the presidency should have done, the executive should have tabled, they should have come under Article 11.7, and tabled a CI for it to mature within 21 days on the floor of Parliament. It then will be regulated by the CI. And then the President could have then used that as a guideline to operate and then exercise that discretionary power. Yesterday, we didn't see any CI. The President went ahead, suspended the Chief Justice, which is part and parcel and form part of the holistic processes of removing the Chief Justice ultimately. So if you want me to show you, a constitutional breach where the President
Have you read One Source France?
Where?
One Source France decision. Have you read it? where the court interpreted 296. Have you read that?
As
No, I'm asking.
no, I mean, when I finish, you may be able to you may be able to put out your principle. But I'm saying that this very constitutional provision is very clear. Then I take you to another constitutional provision in terms of the same 146. You see, one thing you also have to understand that when we are talking about the breach which was also committed by the president, if you look at the correspondent to the CJ relative to her removal, they remove her, one, in the capacity of a CJ and also as a capacity of the justice of the Superior Court, which again is also wrong in law. Now, Victor, you call for it. Let's discuss. We are which again?
Your proposition?
No, it's not my proposition. You see, the constitution is very clear that if I have my subjective proposition and Beatrice have a subjective proposition, ultimately, based on Article 2, we are enjoined by this very constitution to then go to the Supreme Court to seek an interpretation. Boss, is that not what Article 2 is saying? So if I have my proposition and you have, at the end of the day, I agree that there have been a certain school of thought. There are two schools of thought tomorrow. One school of thought, which I know Beatrice subscribes to, is that the moment you are removed based on the stated grounds of misbehavior and all the other stated grounds, infirmity, blah, 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 as a chief justice, automatically you then lose your status as a Supreme Court judge, right? Because their argument is that it will lead to complete absurdity if you are allowed to maintain your status as a Supreme Court judge. And they cite example that say Moro is a Supreme Court judge. Today, Moro has been charged of taking bribe. He has been removed in his administrative role as a Supreme Court judge, as a Chief Justice. Then the same Moro then goes back to the Supreme Court and goes and sit there as a Justice of the Court. Obviously, I mean, when it comes to the test of proving moral integrity, certainly you are not going to meet that test. So on that basis, Beatrice School of Thought is saying that, well, they then assume that the intent of the framers of the Constitution is that when you are removed on these grounds as a Chief Justice or on the stated grounds as a Chief Justice, automatically you lose your status as a Justice of the Supreme Court. That's one school of thought. But I don't subscribe to that school of thought. It is the more reason why then, when these disagreement and discrepancies of the interpretation of the Constitution comes in, we must then go to the Supreme Court for interpretation. Oh, the school of thought that I subscribe to, and which I'm going to point out the constitutional breach again that has been committed by President Mahama, is this. If you look at one, the appointment of the CJ, it is completely different from the appointment of Justice of the Superior Court. I don't know whether Beatrice may have any opposition to that.
That's true.
Yes, that's true. If you look at the appointment, if you also look at the removal processes, the removal of a Justice of the Supreme Court or Superior Court is also completely different from the removal of the CJ. And I take you to Article 1464 and 1466. In terms of the removal, if you look at the composition of the committee that ought to sit on the matter, you realize that they are different. In terms of just the removal of the Superior Court judge, they ought to be 3 judges. Is that not the case?
Yes, sir.
In terms of the Chief Justice, they ought to be 2. Again, if you look at the determination of the prima facie case, it's also completely different.
Okay.
Based on this very same constitution. The prima facie case, one, in the case of removal of a Superior Court judge, it is made by the Chief Justice. But in the case of the Chief Justice, it's also made by the President in consultation with the Council of State. And again, even after the whole committee has sat on the matter and come to the very conclusion that, well, we believe that the prima facie case has been made against you and we recommend that you ought to be removed. In terms of even the transmission of that very recommendation of information is also completely different based on the same constitution. Mm-hmm. In the case of a Superior Court, removal of a Superior Court, the constitution is very clear that it has to go through the Chief Justice before it gets to the President. But in the case of the Chief Justice, it has to go through directly to the President. So my argument is that if the framers of the Constitution had intended that they had intended for the removal of the Chief Justice to be same as the removal of a Superior Court judge, they would have made it explicitly clear. Okay. We don't have such provision. So in this particular instance, what President Mahama should have done, or of course the NDC should have done, was that after finding the prima facie case against the Chief Justice rather ought to have been removed from her administrative role. Moreover, you agree with me that in this country, we have had acting chief justice before. We have acting chief justice. But your status as a judge of the Superior Court has nothing to do with your role as a chief justice in that administrative capacity.
Okay.
So it is a more reason why we have never had an acting judge before, an acting Supreme Court judge before, but we always have acting chief justice. So the whole communique to the chief justice, removing her from her administrative role as the chief justice and proceeding to also remove her as a justice of the Superior Court, it also again smacks some level of unconstitutionality and also breach of the Constitution. Okay. Record and Chroma 1. Of course, I mean, not necessarily to compare the two constitutions because they are two different constitutions. Right. But in the case of Nkrumah, 62 years ago, when we removed Akukosa, he was removed in the capacity as a chief justice, but not as a judge of the Supreme Court, of the Superior Court. He still maintained that status. So I have been able to successfully point Beatrice to two instances where...
Leave that to me.
No, but I mean, obviously, I don't expect you to agree wholly. I mean, certainly, as a lawyer, you also come with your points, which I respect so much. But I'm saying that in terms of the procedural breach, again, even still on the 296, in terms of the CI may also even be interpreted with the procedure. Beatrice, you keep distracting me.
Okay.
The CI may also be also interpreted to even the procedure of hearing by the committee. As at now, my understanding is that they use the CI 47, which is also even in contention. And in people, even the woman, the CJ herself was even challenging the legal basis of the use of the CI 47.
Okay.
And other school or lawyers also, or school of thought also believe that there should have been a CI to regulate this proceeding. Of course, there have even legal precedents to that. The Utaderi case, for instance, the court was very clear that in terms of such proceedings of removing or a judge of the Superior Court, there ought to be a special CI for it, which again was also not followed. So when you ask of constitutional breaches, there are myriad of them.
Okay.
But at the end of the day, you cannot seek to approbate and reprobate.
All right.
You are asking of constitutional breaches. At the same time, you committed those breaches, and then judging the Chief Justice by certain breaches that she's committed. Okay. Of course, the Chief Justice is not a saint. I will not sit here and say that the Chief Justice is beyond reproach. No, she's not beyond reproach. But moral, let us not create a system where we reduce the fate of the Chief Justice to how a president feels. Let us also not create a system where we then rewrite the provision of Article 146 to construe that the Chief Justice now becomes an appointee of the president. So that tomorrow, if MPP comes into office, of course, I mean, I do not believe in that tit-for-tat style of government. I feel that we should graduate from there, just like she was talking about, a developmental politics. I am also of such a firm view that we should graduate. More, you keep signaling me, but you gave 34 minutes.
You've done 30 minutes.
I'm not done. It's 58. 58 minus 34 is what?
Okay.
But anyway.
Okay, no. Try and learn quick so that we can get to concluding remarks.
But anyway, let me learn. But emphasis has to be made that the fate of the Chief Justice should not be left to how a president feels. Okay. But ultimately, if Beatrice and President Mahama feels that they've done the right thing, they've done so well, we leave them to their conscience. Okay. Posterity will judge them. If they believe that what they've done is something that deserves recommendations or commendations, we leave them to their conscience.
All right.
But at the end of the day, Ghanaians are not stupid. Ghanaians understand what really has transpired. Okay. Ghanaians have understand, and they truly understand that a president has come after the first time this happened was 62 years ago. The president has come, now targeted the judiciary, weakened the judiciary, and the same president then parades himself as a president coming to reset. I don't know if this forms part of the basis of the reset. Then it's a dangerous reset for all of us. Okay.